Yes, please.
Action number 1 and 2.
My lord, your lordships had directed the state. My lord, your lordships had directed the state MEPGCL to file an affidavit, my lord,
Yes.
and to bring on record the developments that have taken place subsequent to the award of the contract. Now, they have filed something, my lord, a status report, but I have filed an objection to that, seriously objecting to the manner in which, my lord, the materials have been sought to be incorporated. If your lordships will go through this affidavit, which they contend to be a status report on the affidavit, my lord, neither it discloses the sources from which the supporting documents have been picked up, nor does the authority by whom it has been maintained, nor the official records to which it belongs. My lord, there is a set of rules in the High Court, my lord, which requires them to file an affidavit in a proper manner by indicating the source from which the materials are brought on record. Now here, my lord, it's a 2-page affidavit, my lord. It does not even verify the statements, does not even qualify the materials.
Please read out the affidavit.
My lord, paragraph 2 onwards, my lord, they have filed it on 18th of June.
ये तरफ जाएगा चेयर. Yes.
Now, they have filed this on 18th of June, my lord. Paragraph 2, your lordship will kindly see. Now, may I read it out to your lordship? The instant status report is being filed on behalf of the writ appellant pursuant to the order dated 12th June 2025, passed by this honorable court in the instant proceeding. That it is humbly submitted that the detailed progress report containing the specifics of the work completed, along with the photographs showing the work completed by the respondent number 2, is annexed herewith and marked as Annexure A1. Now, if your lordship will kindly turn to this Annexure A1, it reveals, my lord, a very startling thing. Annexure A1 at page 5, and that is the statement, my lord. It does not disclose that where from this Annexure 1 has been brought on record, whether it's a part of any official record or whether it's a record maintained by them in due course of time, due course of execution of the contract. Nothing of the sort is disclosed. And this, the Annexure A1 is drawn by someone, executive engineer. The affidavit is filed by someone, additional chief engineer. The other pages that have been incorporated here, if your lordship will kindly see, these are pages created, self-serving pages created by them at different points of time by different personalities. That's why, my lord, I have raised an objection. I have filed my rejoinder to this, my lord. The High Court rules say that if you file an affidavit on the official records, my lord, you are to disclose the source, where from this has been picked up, and how these have been brought on record. My lord, if your lordship will kindly take my reply affidavit, my lord, that we have filed on 21st of July. If your lordship will kindly take the paragraph 4A at page 2.
For our purposes, we are only concerned with this. Date of commencement 16/2/2024. Work stopped 6/6/2024. By that time, 7.29% of the work completed and valued at 23 lakhs plus.
My lord, that in my
all.
My lord, in my humble and respectful submission, my lord, that
It
also
is not for any other purpose.
My lord, that also
It is
cannot be the case.
For the purpose of balancing equity.
My lord, in my humble submission, my lord, that cannot also be the case. Your lordship will kindly notice that what was the work
And
order?
the affidavit is verified by the additional chief engineer as to the best of my knowledge.
Now, how can it be as to the best of our knowledge, my lord? On this 4th of June 2025.
How can a rival contractor raise all these points?
No, my lord, I am not raising it as a rival contractor, my lord. I am raising it for the
In the event we find that the contract should have gone to you, since this much of work has been completed by them,
Now-
we will think whether this would be a wasteful expenditure of the government or not to drive them out and to bring you in, because you will be starting de novo.
No, my lord.
For that purpose only.
No, my lord, there is also another consideration on this, my lord. If they are going to say this, my lord, and if your lordship is going to accept this contention that the work commenced on 16th of February and the work was completed to the extent of 7.29%, my lord, I have serious objection to this, that because of the reason, my
For that
lord.
purpose, Mr. Datto, that suppose you win in the matter, there were two options. Number one, terminate their contract and allow you to do it. That would be feasible in the event the work completed was zero.
No,
It was not started.
no.
Since it is 8% through and of the value of 23 lakhs and odd, so the question would be whether to, in the event, we are not saying that we have, in the event you are successful, whether to cancel the contract and allow you to do the work or to give you some damages.
No, my
That's
lord.
all for that purpose.
My lord, my respectful submission is this, my lord. The Honorable Single Judge has already said that the work order should be cancelled. The reason is that, my lord, not only on the question of cartelization and all, it is also visited by stark irregularities and illegalities. The manner in which, my lord, it was doled out, my lord.
On that, you have made detailed submissions. We will go into that. This affidavit,
my lord, I think
this affidavit was for the purpose of our reliefs.
My lord, if your lordship will, now that's why, my lord, I am saying whether this affidavit can be taken into cognizance at all. My lord, if your lordship is asking them to file an affidavit on record, my lord, then there is a rule in the High Court rules which requires them to file it in the proper manner. And my humble and respectful submission is that this affidavit does not qualify to be termed as an affidavit, and these facts stated in the affidavit does not stand for consideration at all. Because your lordship, if your lordship will kindly take my response at page 2, my lord. And in the affidavit, my lord, although they have stated here that work commenced on 16th of February, your lordship will also take in account the first submission that they made before the Honorable Single Judge on 28th of February that the settlement was yet to be made. In such a scenario, how can this be believed that the work was commenced on 16th of February? It was their statement recorded by the Honorable Single Judge in the order sheet. Well, before I take your lordship to that, my lord, your lordship will kindly take up my response at paragraph 4A.
Where's the agenda? Yes.
My lord, I'm just reading it to your lordship, my lord. Paragraph 4A. May I, my lord? First of all, the annexure A1 appended to the affidavit is a self-serving manufactured document having no basis in the official records of the appellant. At least the affidavit filed in support thereof does not even assert that the contents of the annexure A1 have been extracted from any official records or file maintained in connection with the subject contract work. In this context, I humbly and respectfully refer, amongst others, to the provisions of the Rules 25 and 26 contained in Chapter 4 of the High Court Rules and say that the affidavit under reply is in derogation of the mandate of the provisions, among others, of the said rules and as such cannot be acted upon. Well, my specific case is that, my lord, this affidavit cannot be acted upon at all. The Rules 25 and 26 are extracted herein below. The facts on personal knowledge. My lord has said that the additional chief engineer has said that this is based on our personal knowledge. When the declarant in any affidavit speaks any fact within his own knowledge, he shall do so directly and positively using the words I affirm or make, oath and say. Facts other than those based on personal knowledge. Now here, if your lordship will just once again go back to the affidavit, my lord, paragraph 6, she says that the statements made in the above paras are true and correct to the best of my knowledge, belief, information derived from the records. Now, which part is belief and which part is records? Now, going back to Rule 26, my lord, when the particular fact is not within the declarant's own knowledge, but is stated from information obtained from others, the declarant shall use the expression, I am informed, and if such be the case, should add and verily believe it to be true, and he must also state the source from which he received such information. But this is clearly absent, my lord, in this specific affidavit. I could have understood, my lord, if the annexure A1 was drawn by the additional chief engineer himself or herself, and she would have made it as a part of affidavit, my lord, it can be understood. She is relying on some piece of paper purportedly drawn by somebody else. Where from this has been extracted, that is not known. Whether it is from any official file of the respondents, not known. Whether it is prepared in pursuance of any...
Why should she say so? It is her office.
No, my lord.
If it is your office and your clerk takes out some papers, you will say that I have derived this information from the clerk.
No, my lord.
It is your information. Why can't you say
No. My lord, if it is
the
from...
principal.
My lord, if it is from her office, she should indicate the source. Is it the annexure A1 does not indicate that it is extracted from some official records.
If it is from some outside source, yes. It is my office, my source.
No, my lord,
It is true to my knowledge.
My lord, if your lordship will kindly see the annexure A1, it does not contain any file number.
Instead of going into these technicalities, Mr. Dattu, if your client had any case, he would have gone to the site and take 5 pictures and annexed it to show that it is all ground, no work has been done.
No, my lord, I also do not say that it is there is no work. What I say, my lord,
if he tries to rely upon High Court rules to in relation to a contract, nothing can be more unfortunate.
My lord, High Court rules are meant for compliance, my lord. High Court rules are meant for compliance, my lord, because your lordship in writ jurisdiction is acting on the affidavits, my lord, and the affidavits must have some sanctity of proof, my lord. Where is this? Your lordship will kindly see this is signed by executive engineer. The next very page is signed by some assistant executive engineer. The next very page is signed by some other junior engineer. Now, who is to come before it? And who is to bring these materials before the court? And all these pages, there is absolutely no indication where from this has been extracted. Had it been a part of the official records, my lord, at least they must say that this is available in this particular file. Now, merely your lordship has directed them to file a status report. They prepare some piece of paper by their sweet will without making any declaration of any sort, where from this has been procured, who has prepared it and why was it prepared, and they pass it on just like that. And one important thing that why I am objecting to it seriously, if your lordship will kindly see, the award of the contract was passed on 15th of February. I approached the Honorable Court on 27th of February. 28th of February, when the matter was moved, if your lordship will kindly come to the annexure, 27th, to order of 27th, well, that is in my affidavit itself. Well, the second paragraph, as your lordship got it, my lord, it's page 12.
When was the contract awarded?
The order of the day order is 15th, but the terms and conditions of the contract required some post-award compliances to be done as well. I'll take your lordship to the various clauses of the contract, my lord. It required obtaining of permission from the Labour Department. It required obtaining of permission for the purpose of Workmen's Compensation Act and many things else. Work order was dated on 15th. They were to execute an agreement between the parties.
15th February.
15th February.
Year?
2024.
Yes.
And the order dated 27th, your lordship will kindly see at page 12. I pray for an interim stay, my lord, in the writ petition that was objected by the MEPGCL. I prayed for an interim stay. It was objected by MEPGCL. And after the deliberations, my lord, this is what the Honorable Court records. Mr. A. Kumar, learned AG, assisted by so-and-so, is present on behalf of the respondents number so-and-so, so-and-so. And so no further notice is called for in respect of these respondents. Petitioner to take steps for service of notice on the remaining respondents by registered AD within 3 days. Settlement of the contract, if any, will be subject to the outcome of these proceedings. The projection made before the Honorable Court was that the contract was yet to be settled. Why? Because on the work order itself, it was written that they will have to go to the office.
Contract is executed. It will abide by the results of the writ. Contract is executed.
No, my lord. That was the projection made on that day that the settlement was yet to be done. The reason this projection was made was that in the order of the work, in the work order itself, my lord, there was a clause that they will have to visit the office for signing the agreements. And the statements made was the agreement was yet to be signed. The post-award compliances were yet to be made. And therefore, my lord, this observation comes that settlement of the contract, if any, will be subject to outcome. Now, after knowing all these things, if you start the work, and now can you logically and legally plead for equity? Your statements were that projects that it was yet to become. How come this annexure A qualifies that the project commencement is on 16th? Is it a case that man and material were already moved into the site, knowing fully well that the contract will be awarded in their favor? So, therefore, my lord, my insistence is for this simple reason that had it been from some official records prepared by somebody in regular course of official work, at least the affidavit should disclose it, where from this paper has come and why was it drawn on 4th of June 2025. In the entire of the proceeding, my lord, the clear stand goes that settlement is subject to contract. Then finality of the work order is, my lord, I will also take your lordship to those orders, my lord. Finality of the contract will be subject.
Mr. Datto, we are not here to, if you want to make your arguments pointed, you make it pointed. We don't have weeks and months of time to hear all this. Elementary things of contract. Contract is executed by acceptance, subject to signing of the formal agreement. Now don't take
where is that agreement, my lord?
And subject to the condition.
My lord, I'll ask them, my lord, where is that agreement?
That work order is itself the agreement.
My lord, that
now if you take us into those agreements,
with all
please
respect,
excuse
my lord,
us.
my lord, with all respect, my lord, I'll beg to differ, my lord. The work order cannot be qualified as an agreement.
You beg to differ in the Supreme Court. But please don't take us into this, right into the most elementary things of contract law.
No, my lord, I am not taking it, my lord. It is because of their.
Please make your submissions and file your notes. That's all.
My lord,
we should be very strict now.
My lord, if your lordship will kindly consider this, they are trying to dislodge
nothing. You are an unsuccessful contractor. You have your limits of objection.
My lord, the honorable single judge has returned a finding in my favor. My lord, honorable single judge has returned a finding in my favor.
On the way the tender has been conducted.
Absolutely, my lord.
Yes.
On the way. Because ultimately in the judicial review, my lord, your lordship will
now
not...
you cannot as a contractor say that I will go into the nitty-gritties of the records of the department.
My lord, for that matter, my lord, in my respectful submission,
I will give a new dimension to the law of contract.
My lord, already this retail has taken a new dimension.
This is a contract subject to fulfillment of conditions subsequent.
Yes.
Namely, obtaining these permissions, etc.
Now,
if these permissions are not obtained, then the contract is will not be executed.
Therefore, my lord, the question remains how the contract can begin on 16th.
You are nobody to ask that.
My lord, with all respect, my lord,
they have begun. Our simple point is at the time of stoppage, how much work was completed, percentage of work, amount of work, how much was due. That's all.
Now, my lord, if your lordship is going to permit an illegal beneficiary to also take the benefit of equity, my lord,
that we will see.
My lord, in that case, your lordship will kindly allow me to complete my arguments.
Yes, please complete your argument, but don't take us into the
no, my lord,
this kind of a rough ride into elements of contract law.
No, my lord,
just because the learned judge has used the word settlement of the contract, you will use this word to just misconstrue the whole thing.
My lord, in that case, your lordship will...
Settlement of the contract, if any, will be subject to the outcome of these proceedings.
My lord, in that case, your lordship will also kindly see...
Which means that execution of the contract will abide by the results or performance of the contract.
My lord,
That's all.
My lord, here there are two parts.
As we very frequently use in our orders, this will abide by the results of the writ.
In that case, my lord, your lordship will kindly see the next order, my lord. If your lordship is taking that view of the, interpretation of the order of the Honorable Single Judge, your lordship will kindly see the order at page 15. In page 15, my lord, I bring it to the notice of the Honorable Court. Records were also produced. It was examined, and thereafter the Honorable Court forms an opinion that an affidavit is necessary. If your lordship will kindly come to page 15.
15 of your affidavit?
Yes, my lord. Sorry, my lord, it will be 16. The order dated 10th of April. Records have been produced. May I just read it to her? Records have been produced by the learned counsel for the respondents today. Examination of the same reflects that an affidavit is necessary to be filed by the respondents. So-and-so, assisted by so-and-so, on behalf of the petitioner, has submitted that the work has since commenced. This was the statement made by me, my lord, on 10th of April. They commenced the work in the month of March, later part in the month of March. Now, next paragraph, it is made clear that if the submission is correct, any further work will be subject to the orders of this court.
Yes.
Now, who is to be blamed for this, my
Now,
lord?
the learned judge did not say that prima facie there is no contract stay of any further work. But his lordship said, you continue subject to the result of the writ.
Now, can they take the benefit of this continuation? You know it for sure that the Honorable Court is...
That is a different matter.
The Honorable Court is in season of the matter, passing orders one after another. Still you continue with the work, and can you now take a plea at this stage that 7% or 8% I have completed and therefore I should be compensated?
They have not taken that.
No, my lord,
It is for us to formulate our release.
No, my lord, in the affidavit filed by the private respondent, my lord, they have taken a plea that I have commenced the work, I have completed this much, and therefore at this stage it should not be disturbed.
No, I did not.
No,
do that.
in his affidavit, my lord, in her affidavit, she has said that she has completed 40% of the work.
Do not make unnecessary statements.
Now, thereafter, my lord, therefore, here your lordship will kindly see, these, I would submit, my lord, these dates are very, very crucial. If the work had commenced on 16th of February, as they say, and it had stopped on 6th of June, as they say, now what prompted you to draw this on 4th of June? On 4th of this, your lordship will kindly see the annexure 1. How on 4th of June you can write that the work stopped on 6th of June? What is the necessity of drawing this document on that particular day? What is the necessity, and where from this annexure A to A? I'm sorry, my lord.
Where is the 4th June document?
I'm sorry, my lord. It is 1st July. Next page, page 6. Page 6, your lordship will kindly see. Their affidavit. Their affidavit, my lord. Status report on construction of multi-story, multi-purpose indoor stadium at Nongtrai.
Page 6.
Page 6. Now, this page 6 is drawn by one assistant executive engineer and on 1st of July 2024. Nobody asked them for preparation of a status report on 1st of July. Neither the Honorable Single Judge nor the Honorable Division Bench. What prompted them to prepare it? And what is the basis of these descriptions that so much of work has been commenced? Is it a part of the running bill? If it is to be a part of the running bill, my lord, it has to bear the signature of the contractor. Contractor in the appeal says that she has invested 40 lakhs or something. She has substantially carried out the work. And the MEPGCL on affidavit says that this was drawn on 1st of July, indicative of this. Where from these materials have been sourced out?
There are no dates.
This is simply a chart prepared by somebody on an imaginary date, and it is passed on as a part of records. Next page, your lordship will kindly see page 9. Even the junior engineer is different now. One page is signed by one individual, the next page is signed by a different individual, another page is signed by yet another individual. Lord, in my limited understanding, my lord, these cannot qualify to be an material on record. And even if it is to be understood to be so, it must disclose the source. Your lordship will kindly see page 9. The signatures in page 6 and signatures in page 9, these are again different. If it is a continuation of a report, my lord, it cannot bear signatures of more than one or two individuals who had compiled and prepared it. Page 6 is endorsed by assistant executive engineer and executive engineer, and page 9 is junior engineer and assistant executive engineer, and the persons are different, signatures are also different. Page 6 proposes to be a status report prepared on 1st of July. Page 9 bears the signature of 4th of June 2025. How can this be possible? If you had prepared the report on 1st of July 2024, and if page 7 is a part of the report that you have drawn on page 6, how the signature can be of 4th of June 2025? And there is no statement on the entire of the affidavit, my lord, as to who had prepared it, who had drafted it, why it was done, why it was signed by different persons. Lord, my respectful submission is this, my lord, merely because the additional chief engineer files the affidavit, my lord, your lordship will not allow this to happen. This plays with the sanctity of the records. And kindly see the subsequent pages. These are not even also dated. These are also, my lord, at least the copies that have been served to me, lord, these are so hazy I cannot also even identify if these are the photographs of that particular project or not. And something very fishy, the respondent number, the private appellant, my lord, she files an affidavit saying that she procured materials for doing the work till 4th of June, after 4th of June 2024.
Of course, lordship, because...
No, wait, let me finish my turn.
Don't keep on just...
No, I'll take every pages through the notice of the Honorable Court.
Take.
Well, it's a settlement, my lord, your lordship has seen, where the father bids for the son bids for somebody else, son bids for aunt. It's a matter of that kind. And if your lordship will permit this kind of facts to be brought on record in this manner, my lord, in my respectful submission, my lord, that will be very unfortunate.
Lordship, I'll interfere here, lordship, little. Lordship, this was an affidavit made by the...
If you make your submissions now, you will not get any other opportunity.
I'm sorry.
It will be closed.
Lordship.
Finish. It's your choice.
Lordship.
And in her affidavit, in the affidavit of the contractor, my lord, he produces the tax invoices which are dated 31st of May 2024. One is 31st of May 2024. The others are all 4th of June 2024, 7th of June 2024, after the project, according to the MPPGCL, comes to an end. My humble and respectful submission before your lordship will be, your lordship has been giving a very patient hearing in the matter, my lord. My humble and respectful submission before your lordship will be to require the MEPGCL to bring matters in accordance with law. Well, these are the matters which were never produced before the Honorable Single Judge. They are now trying to unjustify the Honorable Single Judge's order.
The facts in short, as I recollect, there was a public advertisement, not that it was pasted on the door of the office or something like that.
Yes.
Public advertisement. There were X number of bidders. All except your client bid at the same price, which was the
Base price.
The lowest. It could
That
not,
was the approximate, not, I would say, my lord, not the base price, it was the approximate value of the contract.
reserve price, which we call reserve price.
No, they have classified it as approximate value of the contract.
Yes, it could not be below that. All
Yes, it could not be
yours was 1 rupee more.
1 rupee more.
All right. Now, thereafter the authority, looking after the contract, called all of you.
No.
And said that then the technical stage was overcome. Then they called all of you and said that there is a 1 rupee difference. Why don't you settle amongst yourselves?
No, in that process, they did not call me. Had they called me and asked me for a settlement, my lord, I could have very well lowered my bid by 1 rupee. Their case was that it still requires a techno-commercial assessment because the last...
called the lowest tenderers who had all
Yes,
called
yes,
you being 1 rupee higher.
yes.
So at that point of time or contemporaneously, all but one revoked their offer. Left with one, which was accepted, right?
Yes. No, they said that, well, we will not do it, you allow the work to be executed by him.
Yes. So they withdrew their offer.
And I have demonstrated before the Honorable Single Judge, and I will also demonstrate before your Lordship, my lord, that their withdrawal was not as per the norms because they have a defined criteria as to how a withdrawal has to be effected. Even the government of Meghalaya has a defined criteria as to how a bid has to be withdrawn. They did not do it. The last meeting that they held, the committee held, they said that the further deliberations will be done in due course and everyone will be notified. Thereafter, no notification comes. Suddenly, this work order is issued. In between, I keep on writing to them that what have you decided, tell us, inform us, how you are going to assess the bid. They don't disclose anything. The work order comes.
So your point is two points that, or rather, the first point is that if at all those bidders could be described as part of a cartel, since there was a public advertisement, what prevented others from bidding, from putting in their offers? And now your point is that when three left with one, and your bid was 1 rupee higher, why not an auction was called? Why were you also not invited and an auction held so that there could be a kind of a price war between the two, like who would offer the higher?
And there is another element, my lord, because it's a techno-commercial bid. The tender document itself says that merely by quoting the lowest price, it will not eventually determine the successful bidder. The successful bidder will be determined by considering the price vis-a-vis the technical qualification.
That may be a different matter.
That is the matter in the tender. That is the terms of the tender, and I say that since this is the stipulation in the tender condition, that it will be a comparison of technical merit of all the bidders. Where is that? Where is that technical assessment? The last minutes of meeting that has been produced on record now at the appellate stage, my lord, that includes and indicates a resolution taken on 8th of September 2023 that final resolution of the techno-commercial aspect will be deliberated later on. That later on never comes.
No, but as far as I am aware of the law, one who crosses the hurdle of technical evaluation, after having crossed, all are treated at par.
Yes.
Then only the price bid is important.
No, my lord,
now,
here...
after the price bid, one cannot turn around and say that I am technically more qualified, so I will, irrespective of the price bid, I should get the contract.
No, my lord.
Unless this technical evaluation is absolutely malafide, gross abuse of the whole process.
That is my case. That is my case, because from the materials on records also, they have not been able to justify it before the Honorable Court that there was true technical evaluation of the bidders in any sense of the term.
You have to pass that test, that's all. Thereafter, you cannot turn around and say that I am better technically, so my price will not matter.
No, that passing of the test was also not done, my lord.
That is there in the records.
No,
all have qualified.
No, my lord, I'll clarify this, my lord. On one proceeding, my lord, they have said that all have qualified, but when the issue was raised, last minute of the meeting of the committee, they said that the further deliberations on the techno-commercial aspect will be taken up later on. Because I pointed it out that the tender document does not qualify the parameters on which the bidders will be assessed on technical aspect of the matter. And if you have done the technical aspect, kindly inform on what parameters you have judged us. Because it's a crucial thing. The tender condition says that it is not the lowest price. It is the price consideration vis-a-vis the somebody who has a better qualification. I'll just show that to your Lordship. They have the MEPGCL has filed an affidavit, my lord. Their affidavit, it is dated. It is February 2025. In that affidavit, your Lordship will kindly come to page 14.
Whose affidavit?
The affidavit by MEPGCL. Page 14.
Which date? Affidavit.
It is not dated. It was filed sometimes in the month of February 2025.
Got it.
Has your Lordship got it, my lord? Page 14. Now, in page 14, paragraph 7, your Lordship will, paragraph 3, your Lordship will kindly see. Evaluation on technical bid was processed and comparative statement was put up to the tender committee.
Yes.
Clause 3, if your Lordship has got page 14. It was meeting held on 6th of September 2023.
You have shown us all this.
No, my lord, since your Lordship is taking my lord, view that since the technical assessment was done, my lord, that's why, my lord, I am trying to clarify that technical assessment was not done. It was not complete. My lord, in the paragraph 3, that said that technical evaluation on technical bid was processed and comparative statement was put up to the tender committee in the meeting held on so-and-so. As observed by the tender committee, all bidders could not fulfill the required documents as per NIT.
You come to the last paragraph.
Paragraph 7. The bidders submitted...
Not 7.
Huh?
7, then subparagraph.
Subparagraph.
After.
After scrutiny by the members of the tender committee, it was found that all bidders are qualified for the technical bid and to expedite the process. And to expedite the process, the tender committee has decided to allow for opening of the financial bid on 8th of...
That is the recollection I was having, that all have qualified.
Yes. Now kindly see 8th of September, which is at page 17. Page 17, observation, my lord, the prices are quoted. Now after the words conclusion, tender committee members. Now here is a time, my lord, where the tender committee finds that all have equal price bid. Except me, all are equal in price bid. Therefore, the tender committee resolves, tender committee members after observation and discussion agreed for further detailed evaluation of the next course of action. Since it's a tie, naturally the next course of action will be to evaluate the price bid, the technical bids further. Thereafter, nothing happens. Thereafter, my lord, nothing happens as to how the price bid, how the technical bid is assessed. I start inviting their attention to this aspect. I start submitting to them representations. Your lordships have seen the representations, my lord. I'll just make a brief reference to that. Page 112 in the appeal brief, my lord.
Evaluation means technical, they are all have qualified, financial, this is the slender difference. So we will consider what decision to take on the tender. That is what is meant.
Yes.
Now, if that is... if-
This is not that we will open up the technical bit, technical issue,
Now, if it is...
or everything will be considered.
If everything is to be considered, Miller, then I also stand a chance. I also ought to have been called that, look, this is the similarity, this is the price bid, 1 rupee difference. Tell us whether you are eligible, you are going to lower it down by 1 rupee. I will still submit, Miller, because the Honorable Single Judge has seen the records and I had also occasion to briefly go through it, Miller. If your Lordship will call through the records, Miller, your Lordship will see that whether any technical assessment was done. My definite case was that no technical assessment was done on this aspect of the matter.
Maybe, but in a state like this, you will not find so many contractors bidding for this value of the contract. You will get only 5 and 6.
Exactly. And therefore, Miller,
And if this is a public advertisement, and
And-
all have kind of, suppose by arrangement with one another, or about consultation with one another, have thrown in their bid, you can't say that there is cartel and all that.
no, I am not saying, I am for the moment, Miller, I am
Because
not,
It did not prevent anybody from here or from outside
no.
from making a bid.
No, Miller, for the moment, I am not even saying that there was a cartel. What I am saying is that, Miller, the tender condition also said that quoting the lowest bid is not the criteria alone on which it will be decided. Secondly, and most importantly, the tender committee reserves the right, the employer reserves the right to distribute the tender among the successful bidders. That is the first clause of the tender, and it's an item rate contract where without meeting of minds, nobody can come to an exact figure. Well, your Lordship will kindly see that.
We've got your point, Mr. Dattu. Give your notes now.
Miller,
What else?
Miller, I had only submitted one judgment, Miller. Rest of the judgments I am yet to.
On what point?
Miller, one judgment I had cited on that day.
Yes. I think 1993 Supreme Court.
Yes. '97, 1997, one SCC.
Yes, 53. Page
Yes.
53.
Page 53. Tender conditions.
Are you here tomorrow, Mr. Dattu?
No, Miller, tomorrow I am not here.
Can you do it online?
That will be difficulty.
Then please rapidly cite your cases.
Miller, if I am to only complete the citations, Miller, if you
You
Lordship,
give us the propositions, give us the case. We will try to understand it.
Miller, I need some elaboration, Miller, because they have made their elaborate.
Elaboration, then you should have made arrangement for 2 days here.
Good. Or 7th or 8th, because next week, Miller, I am very badly tied up, Miller.
Yes.
8th, your Lordship.
And who else will make submissions?
Now it's up to them, Miller, if they want to.
Lords, briefly, very brief, 1 or 2 points in rejoinder, then your Lordship may wrap it up and allow us to file written notes of arguments.
Yes. Let us find it.
Miss Parveen, Mrs. Parveen,
Yes,
would you like to make some submissions after?
Lordship.
You have already made.
Yes. That content, the affidavit to which he was referring today, Lordship, the made by
But
the
you are co-respondents in the appeal.
Lordship,
You are co-respondents in this appeal.
Lordship,
Then you have already made your submission.
Lordship, I have made my submission. That is
She
why
has also filed an independent appeal, Miller. There is also an independent.
Yes, it will be taken as having made submissions in that appeal as well.
Yes.
no. The thing is, Lordship, I would only say that the whole writ petition was based on false and all deception.
No, it's all
Yes,
right.
That is the thing.
On this kind of a reply, you are only on law.
No,
basically.
Lordship, no. They say that. Lordship,
Or any facts by which you are taken by surprise, by argument. Reply is confined to that.
Lordship,
Not again reiteration.
Lordship.
17th, what were you saying? Well, Mr. Datta, how much time you will take?
Well, about 40 minutes, Miller. Well, I have got at least eight citations, Miller, that I am yet to place before your Lordship.
I too have citations. I have already given in a page, Lordship. I have cited it, the paras. He can also do that instead of taking more time, Lordship, like
Well,
this.
it's about my right of making my
All
submissions.
right.
He cannot
11th
interject.
is all right. 11th.
Well, next week, my lord, I may require to visit my son, my lord. In that case, your lordship may give me on 18th, my lord.
No. Too late.
I can take a chance, my lord, on 8th, my lord. On 8th, my lord.
No, 7th and 8th. This matter has to be finished.
Lordship.
We also need some time.
Lordship.
7th and 8th marked at 12:45 p.m.
Lordship. Obliged,
Yes.
Lordship.
Mr. Datta, learned senior advocate, continues his argument but does not conclude the same. List this appeal, these appeals. Wait. On 7th and 8th, marked at 12:45 p.m. Court it is expected that arguments will be concluded on that day.
And Lordship, if notes to be submitted by them, they can.
Yes. All learned advocates on record for the parties are requested to bring written submissions for filing in court on the next date of hearing.
Lordship.
Because the only difficulty is the 7th and 8th, your lordship has also fixed that matter
Let it
of
be
the-
fixed. Let it be fixed. We have to finish this matter.
Yes.
We can't sit with one matter only. Yes, all the rest.
Obliged.
Item number 3.
My
Yes,
lord,
Mr. Yobit, what is this matter about?
my lord, this is the Haucus matter, my lord.
Yes.
3rd July, my lord has requested the SO to file a report.
His
my lord.
report, Your Lordship. The
Report.
special officer was
Yes.
supposed to file his report, Your Lordship.
Look, I have filed the report. Yesterday I have filed the report. Probably it is before your lordship. But I have not noticed.
Let's
We may be
Supplying the
supplied with copies, Your Lordship.
Copies
We have
have
not
been supplied
received
to
any
us.
copies of the report.
Somebody wrote a letter to him.
Who's for the board, municipal board?
I'm for the municipal board, my lord. I'm entering appearance today, my lord.
You respond to this letter.
My lord, we'll respond, and we have also prepared a report, my lord. The CEO has forwarded me a copy of the report that they have also prepared, my lord. We have executed the order of this.
No, but in that report you deal with the paragraph 13 of the special officer's
My lord,
report.
my lord.
What's
A
it?
copy of the
Copy
report
of
may
the
be furnished to
report.
us, my lord. We'll respond to it, my lord.
He is senior advocate. You ask your clerk to visit
My lord, surely. I will visit, my
his
lord.
office or his
I will visit, my lord.
his clerk and obtain a copy.
My lord, I will visit, my lord.
Well, if your lordship permits, I'll provide copies for all of you.
You ask your staff to.
I'll do that.
Yes, we have. Wait. They are saying that. "12 and 13.
12 and 13.
Let them respond to this. We have examined the report of the special officer. Appointed by our order dated 3rd July 2025. To superintend the exercise of eviction of unlicensed vendors from Kindailad area and for relocation of licensed vendors in the space provided by the Shillong Municipal Board. Paragraph. It appears from this report and the submissions made before us that the exercise has been peaceful and successful. Full stop. However, the Shillong Roadside Hawkers Association has on 25th July 2025 and 1st August 2025 written to the Chief Executive Officer of the Shillong Municipal Board stating that some ineligible stating that some eligible vendors had not been included had not been issued certificates of vending. The special officer who also received a copy of this letter on 29 July 2025 has written to the Chief Executive Officer of the Shillong Municipal Board to respond to this allegation. Full stop. Learned advocate for the Municipal Board assures the court that a proper response in the form of an affidavit will be filed in court. Well, let a copy of the report of the special officer be circulated to all the appearing lawyers by tomorrow, the copies of the report. Let copies of the report of the response affidavit to be filed by the Shillong Municipal Board by 11th August. Be also circulated to the parties. List is public interest litigation once again on 13th August.
Wait, please, my lords. Lordship, I crave leave of the court to file an application under Order 1, Rule 10. I am the Seng Samla, my lords. I'm the youth body of the area. And I wish to be included in this matter, my lords. I'm craving leave.
It is coming up
Of
on the third.
Lamka. My lords.
The Hawkers matter.
Yes, Your Honor.
Too many participation
Please,
will
repeat.
create more confusions, my lord.
Lordship, I am here to bolster the case of the petitioner, my lords.
All right, you file your application,
I
it will
shall.
be listed.
Grateful, Your Honor.
You file the application, it will be listed day after tomorrow. Give
Great.
notice, then we will see.
Grateful, Your Honor.
Item number 4.
May it please
My
your
lord,
lordship. Lordship, your lordship had directed me to file an affidavit in response to the affidavit filed by the secretary to the government of Meghalaya. We have filed it on Friday, lordship. I was supposed to file by 1st August. I
We
have
have
filed it.
received the affidavit, my lord. We are yet to go through, my lord. We
It
may.
is that Weybridge.
Yes, lordship.
So we require some time, my lord, to go through the affidavit filed by the.
Lordship, pleadings are complete. Matter may be posted for hearing, final hearing, lordship. So, in fact, this affidavit is also almost a reiteration of the previous affidavit, only hardly any
That
new
there is
points
no
are-
overloading.
Overloading is there, lordship.
That is their contention, my lord. My lord.
According to your affidavit, no overloading, no
Yes, my lord.
escapement of revenue.
Right. My lord, we require some time, my lord. May grant us at least 1 week time, my lord.
All right. What have you filed, rejoinder or affidavit?
I have filed an affidavit in reply to the affidavit filed by the secretary.
This is item number?
4, your lordship.
All right, please take down. This public interest litigation concerns alleged misconduct on the part of government officials in allowing overloaded goods carriers to pass weighbridges without proper payment and also alleged loss of revenue revenue which is a result of this alleged unlawful activity. Paragraph, according to the authorities, neither of the two allegations is justified, full stop. Pursuant to our last order, they have filed an affidavit to this effect. The writ application has thus become ready for hearing. List this writ application for this public interest litigation for final hearing on 20th August.
Lordship, if it could be on 18th August, Lordship.
All right. On 18th August.
Deeply obliged, Lordship.
Number 5. May it please, Your Lordships. Your Lordships, I'm appearing on behalf of the appellant, Your Lordships, the counsels from out of station, Your Lordships. They've been informed by the other side that they will be seeking time today, Your Lordships.
You're for the appellants.
Yes, Your Lordships. Your Lordships, if I can kindly request, Your Lordship, if this matter can come up in the first week of September, Your Lordship.
Who's appearing? This is item number 5.
Yes, Your Lordships. AS Transportation.
Who's on the other side?
Your
Who's for the
Lordship.
Union of India?
Yes, Your Lordship.
Union of India? Appeal is ready for hearing.
Yes, Your Lordship. Lordship, here we are just a formal party, Your Lordship.
Sorry?
Your Lordship, here we are just a formal party, Your Lordship. The main party. Your Lordship, the main party is respondent number 2, 3, 4, and 5 and 6, Your Lordship.
No, appeal is ready for hearing or not?
Yes, Your Lordship.
Ready, paper book filed.
Yes, Your Lordship.
She wants it in the first week of September.
No objection, Your Lordship.
Yes, Lord. First week of September, Your Lordship.
All right. By consent of learned counsel for the parties, we list this appeal for hearing on 2nd September.
Highly obliged. Much obliged. Number 6.
Yes, Mr. Paul?
This is again one of those cancellation of contract matters, Millets.
So who's for the respondent?
I think my friend.
I'm for the response.
Why not tomorrow, Mr. Pandey? Why make a long jump to next week? Where are you now? Delhi? All right, we'll keep it next week. You come back and rest and get ready for the matter. All right? All right, when do we keep it? No, 18, not 18. Next week is 11, 12, 13, 14. 12th. All right.
12.
Mr. Paul?
12.
All right. By consent of learned counsel for the parties, list this appeal for hearing on 12th.
Obliged.